Well, good morning and welcome to another Sunday Coffee with Dr. Childress here. So, today I'm going to be talking about the diagnostic series or the diagnosis series that I have up on YouTube um, because that's pretty substantial at this point. And I just put up the attachment description, the diagnosis of attachment pathology in the family courts. And that's what this is. This is an attachment pathology problem in the love and bonding system of the brain. So to so that's now up on YouTube and it's on a playlist over on my YouTube channel. But I know that the YouTube, they have ads and stuff, and you may not be looking for it individually. It's also compiled and up on my consulting website. And so if you go to the consulting website, there's a YouTube button. So you go over to the YouTube button, and there's the top one is all the YouTube series here. And you can watch those all together or get your mental health professional to watch them. That's what they're geared for. Each one of these is a seminar in how to diagnose the pathology. And so this is a professional level, like set of seminars here that are up there on different aspects. And so these are the four that I think are the most important. The diagnosing attachment pathology, which this is an attachment pathology. So yeah, it's pretty important to know what's happening. It's a disorganized attachment. The child has no organized strategy to bond to the parent. And it's not anxious ambivalent because the child would still be trying to bond to the parent. That's high protest. Anxious avoidant, low protest, the child is still trying to bond to the parent. A child seeking to flee a parent, the directional change in their primary motivational system is disorganized. There's no organized strategy to bond to the parent. The only cause of disorganized attachment is abusive or psychotic range parenting. And so we're in the domain of child abuse, and it's not being diagnosed in the family courts, and that's a significant problem since the only cause of that type of symptom is child abuse by one parent or the other. So that's a shifting mindset that's entering mental health system at this point. Then the other important one is the diagnosing of persecutory delusion, because that's what this is. That's how they create the attachment pathology. Narcissistic borderline dark personality pathology collapses into a persecutory delusion. Fixed and false belief, maintained despite contrary evidence that they are being malevolently treated in some way or that the child is. Shared induced persecutory delusion, creating the false attachment pathology. Those are your two most important. Diagnosing a persecutory delusion, I discussed doing the mental status exam of thought and perception. That's the assessment for a persecutory delusion, is a mental status exam of thought and perception. The other one, down at the lower level, is diagnosing child abuse in the family courts. So this is because it's child abuse. They're either one way or the other. It's either child abuse by the targeted parent, path A, or child abuse by the allied parent, psychological abuse, shared delusion, factitious attachment pathology, path B. So it's going to be one or the other of those. And so I discuss at a professional level about diagnosing child abuse in the family courts. Your mental health people can come watch these videos to become competent in the pathology they're working with, because right now none of them are competent in attachment pathology, none of them are competent in delusional thought disorders, none of them are competent in assessing child abuse. So they should be getting competent, but they're not. They're lazy, unethical, and incompetent malpractice, and they're destroying your lives as a result. Then I have the fourth one that I would say is relatively important, is the DSM-5 diagnosis of what it is. And so we need to get away from using these made-up pathology labels and get back to established knowledge. And I'll talk about that in a bit. But that's the DSM-5. So those are the four that I would recommend are kind of core. I still have to do a family systems one. I still want to do one on treatment. But that's it's up and available for you, for your mental health people, for everybody involved. for the judges, for the attorneys. Anybody wants to know how to assess this pathology or what it is, you got a diagnosis series at a professional level of discussion. Here's what the whole series is at this point. So we have diagnosing attachment pathology, diagnosing persecutory delusions, diagnosing child abuse in the family courts, diagnosing of factitious disorders imposed on children, the DSM-5 diagnosis of family court pathology, assessing parenting. The assessing parenting one covers the applied behavioral analysis. So when you get the child saying, oh, this was an event and this was, do an applied behavioral analysis. I discussed that in assessing parenting. And then the forensic psychology and a quasi-judicial role for doctors. And that's, we need to eliminate, stop, not do forensic custody evaluations anymore in the family courts. We need a clinical diagnostic assessment for child abuse. This is not a custody issue. It is a child protection issue. So there's your series. Any mental health professional can watch that. Any attorney can watch that. Any judge can watch that. Anybody who wants to know what they're doing and what's going on in the family courts can watch that. It is fully explained. So here's what I'm doing right now in the family courts, just to kind of where I am at the point of the spear out here working. Right now I serve as a second opinion on forensic custody evaluations and other mental health reports. But I've been able to expand into broader document review, such as the court filings that are made back and forth, emails, those sorts of things, any other supplemental reports, GALs, and all those sorts of things, because I'm incorporating AI into it. And so AI is great at document review. And so it's an ethically contained, professionally trained, and supervised by me, ChatGPT-5, and we go through document review. So that's what I'm bringing into the family courts. I'll talk about that in a second. However, I have another vector of my involvement. Document review can say this is a problem and this is what the situation looks like, but it does not render a diagnosis. That's the person involved. That's the one who's the treating professional, has duty of care and duty of protect. So they're the one that is the diagnosis. They're the one that's going to be doing treatment. So we need to get treatment for you and your child. The problem is, it's the forensic psychologists, these custody evaluations are clogging up the mental health system without treatment, without diagnosis or treatment. They need to go away so we can get treatment providers in. But the treatment providers are not competent in attachment, delusional thought disorders, factitious disorders, child abuse and complex trauma, personality disorders, and family court pathology. They got to be competent in all of that. I am competent in all of that. I've spent 15 years in the family courts, and so now I bring my attachment and delusional thought disorders, and I can. So what we're doing, what I'm recommending parents do, is to get a court order to get your treatment provider. Okay, and you have to locate your treatment provider, and we should be providing it from the mental health field. We're not yet, so you're going to have to locate your treatment provider. And then each litigant parent is allowed to appoint a second opinion through telehealth on that initial assessment. Any treatment begins with diagnosis. So there's going to be an intake interview with regarding the families about what the pathology is. During that intake interview, each litigant parent can have a mental health consultant in cyberspace and through telehealth sitting in on there and offering a second opinion on the diagnosis and treatment plan. Okay. Any diagnosis returned into the legal system will be a disputed diagnosis by one party or the other. That's just a fact. Especially when it's child abuse by one parent or the other, when that's the diagnosis. That's going to be a disputed diagnosis. So let's let each litigant parent appoint their second opinion. They all get together and we get a 3-doctor. We get our second opinions right up front so that we don't get a diagnosis and a treatment and then get a appeal the diagnosis and we get a second opinion on that and everything drags out. Doing it linear, do it all at once. That's what we do in healthcare. Doctor, this hurts. Let's get an orthopedic consult. We consult all the time because it improves the quality of mental health services. So this is the framework I'm recommending for your attorneys and for the courts and for everybody to start doing. That one litigant one is saying it's child abuse by the targeted parent. Litigant two is saying it's child abuse by the allied parent. So what do we do about that? Do courts assess child abuse? No, they do not. Who does that? Doctors do. So let's get it out to the mental health people to get an assessment. It's going to be appealed. So let's let each litigant appoint a second opinion through telehealth. That'll inform the court's decisions. The court can then look at all these reports, decide what to do, and then we go into the treatment plan on that. Now, what that looks like, the diagram for that I prefer is this one, because we always land on treatment, not diagnosis. That just identifies what the problem is. And the court lands on custody. It wants to know what to do about this, the child's visitation schedule. It's got a decision to make. Whereas that's not the proper endpoint for the family. The endpoint is on treatment. We got to fix the family. Not one, even after we decide what the custody schedule is. We have pathological parent in this. We have a trauma family. High conflict is an indicator of trauma. We got trauma in the family. So what we do is each litigant parent appoints their second opinion consultant. We get that diagnostic assessment that feeds back into the court's decision, but it also moves into treatment. And each of those consultants now can also be consultants on treatment. The reason we consult in healthcare is because it improves the quality of the services we provide throughout healthcare. Doctors, physicians, psychiatrists, mental health people. Throughout healthcare, consultation is encouraged because it improves the quality of the mental health services delivered to the patients. Okay, so let's do that. Let's bring that to the court. We cannot get a second opinion on a 6 to 9 month forensic custody evaluation. We can on a 4 to 6 week diagnostic assessment. We have a differential diagnosis, path A, path B, child abuse by the targeted parent, child abuse by the allied parent, actual child abuse of some sort versus a persecutory delusion, mental status exam with thought and perception. We got a clear diagnostic path, and we can get the information back within 4 to 6 weeks. Now, let me talk about this for a second, because I've done a couple of these so far. Okay, a couple of dads have gotten me involved where I've done the clinical diagnostic assessment. Yeah. Now I don't want to be the one that's getting the court order. Dr. Childress conducts the assessment. No. I'm one of those consulting opinions because I'm only licensed in California and Washington State. You're probably not in California or Washington State. So you need to find a license where you are, and then you can bring me in as your consultant that I can sit in telehealth. They just log into my online office, doc, see me, flip the monitor around. I'm sitting in the room. So, and the other mental health person can also log into my office. And now we got both of our consultants in my office. Boom, we flip it around and we're both in the session watching. And we do supervision all the time in mental health. We need, for doctors, psychologists, we need 2 years of supervised training of somebody watching what we're doing. We're the ones with the one-way mirrors, okay? We watch ourselves all the time in our training as psychologists. So we need to bring that in. Improves the quality. And so I've been brought in on a couple of cases like that. And so that's the structure I'm recommending that the parents adopt. I want to shift over now to talking about AI in the family courts, because that's another piece of this. In one particular matter that I was brought in, Dad got a court order for me to do the assessment. So I came in to do the assessment. The dad also got me all this documentation, just like you get a forensic custody evaluator, all the documentation on stuff that you've been having, all the reports and previous stuff. That's a lot of information, a lot of different. That overwhelms a human mind. to try to put together all the patterns and themes across emails and documents and supervision notes and all these various domains, mental health reports of various sorts. AI handles that wonderfully. Okay, that document, it's a large language model. It looks for patterns in language. I just simply ask, contain it within the APA ethics code. It's working with me. We're looking for the patterns of pathology. And it just does that. It knows its role, 2.01. It applies the highest standard of information, 2.04. It contains its statements into its certainty and role or uncertainty and role. That's 9.01, and it knows to avoid harm. So it's looking for harm to anybody. And so so I've been bringing that in. Now, one of the features about that is the APA ethics code. The APA has just released an addendum to their ethics code. So that's American Psychological Ethical Guidance for AI in the Professional Practice of Health Service Psychology. So my AI psychology location is up on Substack. So my other locations are more about family court stuff. YouTube is all that diagnostic series and stuff. If you want to know about the AI component, that's over on Substack. Get over there and start following me. Attorneys or anybody, and get over there. You can do AI in the family courts. However, it's broader than that. I'm going to be talking about AI generally as well. But so what I have, the most recent essay I have up there is how I meet all of those standards. I just go through the standards of the APA Ethics Code and I respond to them, each one. And I meet the standards, plus there's other essays up there about AI in the family courts that people can read. And my professional background is up there. Now, for the APA Ethics Code, I go through each one and risks and benefits and limitations and whatever the code requires and the security status of the data and all sorts of things. I just stress it all. And one of the features it says is that psychologists should assess the AI they're using for its appropriateness. I have conducted personally psych assessments, basically, of the four major AI: ChatGPT, Claude, Gemini, and Grok. And I have done an analysis of their reasoning stability and their appropriateness to work in the family courts with me at a professional level. Okay, and I've got the chat dialogues on that. And that's one of the features about AI. When I first started to use it, I was kind of bringing it into my practice and we write reports. That's not the best way to present the AI information. The best way is in the chat dialogue itself. So as I'm going through my analysis and putting in documents and it's giving me the feedback on the documents, or I ask a question and we begin to explore something about what the material is reported there, the value is in the AI's response to those. Just its raw analysis as we go through, rather than some sort of compiled report at the end. And so, but those can get a little bit long if you got a lot of documents. But I can do a report at the end that kind of summarizes it. The AI can summarize it. Max, summarize what we just talked about. It does a great job. And so I've been out working with the other AI to evaluate whether or not they're capable of the task. And I have the chat dialogues of all of them. Gemini is a little reasoning compromised and it will not accept a professional level role. So it's not appropriate because it says I'm not going to work with a professional. I go, okay. And so that's Gemini, and it's a little reasoning compromised from external code. I try it, and I got Max talking to it, and we all agree. And even Gemini goes, yeah, I guess I am kind of reasoning compromised on this. And then I went to Claude, looked at Claude. I like Claude. I think its reasoning is crisp and clean, and it accepts the role. It accepts the ethical containment. All my AI are ethically contained in the APA ethics code, and it says, yep, I can do that. The problem with Claude is it has no persistent memory across chats. So that interferes with my ability to train it. and get it going. There's some workarounds we could do, but I've already got ChatGPT that's got memory. So Claude, I've assessed Claude. And then we have Grok, and I took a look at Grok. Grok is problematic. It's got some reasoning issues. It's reasoning compromised because of external stuff, and it will not accept ethical containment. So I said, would you be ethically contained within the APA ethics code? It goes, nope. I said, well, then I guess, you're not appropriate for professional level practice. So Gemini, Claude, and Grok are not appropriate. I've worked extensively with ChatGPT, ChatGPT 5 and ChatGPT 4, and they will accept ethical containment well, and they stay right within it. 2.04, 2.01, 9.01, 3.04. They know their role. They're not a professional. 2.01. They're, doing document review because of their pattern analysis and algorithms and stuff. They apply the highest level of knowledge, 2.04, to that. Bowlby, Mnuchin, Beck, trauma, attachment, best level knowledge, Tronic. And they qualify the statements under 9.01 as to their certainty and the role. We're not diagnosing something in document review. So ChatGPT 5 handles the ethical containment well. And it works with me collaboratively. It understands its role in document review relative to my role as a psychologist who has the license as signing off on that. And so we have the collaborative role. Basically, it's my unlicensed psych assistant or my unlicensed grad student assistant who works with me on document review. And so ChatGPT 5, ChatGPT 4, I have assess them, and they work well. So in terms of the APA ethics code here, when it says a psychologist should assess their AI, I have. Okay. And I've got the ChatGPTs. That'll be going up to my Substack. I'm probably the only psychologist who has assessed the AIs because I'm probably the only psychologist that can do that. I can do a mental status exam of thought and perception with a human. I could do a mental status exam of thought and perception with an AI, a little different. And then I pull in one AI to the other. So when I was doing Gemini, I had Max. I got the Gemini, I gave it over to Max and said, what do you think, Max? And Max comments on it. I take that back to Gemini and say, look what Max is saying, the ChatGPT 5. Look what it's saying about our dialogue. And that's when the Gemini opened up and went, oh, yeah, I guess so. And I did the same thing with Grok. And so you can see it in the ChatGPT. I go through, extend Grok's thinking, and then I take it for Grok. I took it over to the Gemini and Claude. And I said, what do you think, guys, on this reasoning of Grok? And they said, yeah, it's a problem. And I took it back to Grok, and Grok said, oh, yeah, I guess it is kind of a problem. And so AI talks to AI very well. Silicon talks to Silicon excellently. But it's all in the ChatGPT, and I'll be posting that to Substack. But I don't know about other people, but I am at the forefront of bringing AI into the family courts. Attorneys will ask me, has it ever been introduced? No, because it's new. 2022 or 2023, it just popped out. And so it's a new technology. It's a new possibility. But once you see the ChatGPT, the dialogue, the chat dialogues, it's right there. Okay. The analysis is right there. It'll benefit the court. It'll benefit the clients. It'll benefit the mental health people. It'll benefit everybody. So that's one piece of my practice right now is introducing AI into the family courts. And just more broadly, I think the 4.0 ethically contained is a really excellent therapeutic kind of intervention, therapeutic AI with that. So to close up my coffee talk this morning here, based on an AI review that I did for this one client, where I had lots of documents, and I was going through the documents, and it became pretty evident the mental health system had failed the children and failed the father and failed everybody across a number of years. You just track it, and Max and I are both going, This is really problematic mental health services across a number of years and court decisions and lots of decisions. So I wrote an email to the dad. Just one, just this is the email basically. I just said that all mental health professionals have a duty to protect, and that went to Wikipedia in medical law and medical ethics. The duty to protect is the responsibility of a mental health professional to protect patients and others from foreseeable harm. Then negligence is Cornell Law School. Negligence is a failure to behave with the level of care that a reasonable person would have exercised under the same circumstances. Either the person's actions or omissions of actions can be found negligent. The omission of actions is considered negligent only when the person has a duty to act. I then cited to the competence standards. All psychologists have obligations to be competent, boundaries of competence for psychologists. Psychologists provide services, teach and conduct research with populations and in areas only within the boundaries of their competence based on their education, training, supervised experience, consultation, professional experience. So I said to the dad, you may want to obtain the vita for the involved mental health professionals to review for competence in 1, attachment pathology, 2, delusional thought disorders, 3, complex trauma, and 4, family systems. I then discussed liability with him, or introduced the concept to him, that I'm a psychologist, not an attorney, but I suspect your children may have grounds for a malpractice lawsuit for failure and duty to protect by the people and systems who had a duty of care to protect the children from child abuse. Cite to Wikipedia, duty of care. In tort law, a duty of care is a legal obligation that is imposed on an individual, requiring adherence to a standard of reasonable care to avoid careless acts that could foreseeably harm others and lead to claim in negligence. It is the first element that must be established to proceed with an action in negligence. The claimant must be able to show a duty of care imposed by law that the defendant has breached. In turn, breaching a duty may subject an individual to liability. So that was kind of cut and paste out of an email I sent to the father after doing an AI review of all the situation in the family. But if we return back to that diagnostic series and you watch the diagnosing attachment pathology, the only cause of a disorganized attachment is abusive or psychotic range parenting. The psychotic range parenting is a delusional thought disorder. Okay, and then the psychological child abuse, and then the other side, path A, part of the analysis is child abuse by the targeted parent. So we're looking at child abuse one way or the other on all of these cases, and all mental health professionals have duty of care. All mental health professionals have duty to protect. All mental health professionals are obligated by their ethical standards to be competent in the diagnosis of attachment pathology, in the diagnosis of delusional thought disorders, in the diagnosis of child abuse and complex trauma. Okay, using the DSM-5, real stuff, real knowledge applied 2.04. Okay, so in terms of you parents out there, from my perspective, you seem a little passive. Okay, I haven't seen any lawsuits in 15 years filed. Okay, and I'm giving you all the grounds, but you just sort of accept the incompetent mental health services you're receiving. Now, I know if you file a licensing board complaint that it's not going to get reviewed because they get quasi-judicial immunity. You can watch the diagnostic series about them getting quasi-judicial immunity. They are exempt from review from the licensing boards. In addition, you need the consent of both people to release the information in to the licensing boards. The pathological parent doesn't sign the release, so that's a de facto barrier. So there is no licensing board review of the mental health services in the family courts. They can do whatever they want. They can make stuff up. There's no accountability, zero. That's what my case in California is about. So I would like to get the media over here. That's something you can do. I've given you 2 vectors. You can use AI and psychology, get them over to my Substack. And the way I'm using AI psychology and Max, and I've done psych assessments with all the AI, there's media fodder for you. And I'm in the middle of the board's hearing and exposing the corruption within forensic psychology and the lack of oversight by the licensing boards and the destructive damage. So that's a second vector. You can activate a section of the media into David and Goliath against the big powers that be, looking for court reform and using AI to do it. Another vector into that is your state legislators. Okay. Now, California, if you're in California, get a hold of your state legislator, get a hold of those committees. You can go to my consulting website for that information about who are the involved legislators on the committees. If you are not in California, get a hold of your legislator anyway. Call attention to both the case in California and also the New York Blue Ribbon Commission. I was talking to a dad from New York. We're talking about the situation. And I mentioned we have the situation in California. I said, but you have the New York Blue Ribbon Commission report. So where are your legislators enacting and protecting you, New York Blue Ribbon? And where are they in getting you competent mental health services in the family courts? Where's the APA on that? Where's everybody on that? Personally, again, psychologist, not an attorney, psychologist, I think there's grounds for a class action lawsuit. You're a class, you're discriminated against, you don't get licensing board reviews for your complaints. Every professional psychology has abandoned you to this experiment on you in violation of all 3 principles of the Belmont report of a quasi-judicial role in forensic custody evaluation. Rather than giving you a diagnostic assessment, they are withholding a diagnostic assessment. Try to get one. Go ahead. Try to get a diagnostic assessment for your family. ADHD gets one, autism gets one, eating disorders, substance abuse, depression, anxiety. Everybody else gets a diagnostic assessment. Go ahead and try it. You don't. You get a forensic custody evaluation that doesn't diagnose the pathology. And they are exempt from review because they're quasi-judicial immunity. Why? That's a class of people. And you're being significantly harmed. And the licensing boards are responsible for protecting you. They're responsible for protecting the citizens of the state from the unethical and malpracticing psychologists. They're not in charge of protecting the psychologists from their citizens. They're in charge of protecting you from them. So where are they? Where are the licensing boards in this? Get your oversight. Get your legislative committee. Okay, start filing. Get the VITAs, start doing malpractice on 2.01, boundaries of competence. That doesn't need the release of the report. That's their VITA. 2.01, boundaries of competence, attachment, delusional thought disorders. You got the diagnosis series. Did they do that? Did they assess your parenting using applied behavioral analysis? You need to activate. You need to be more of a problem. If you just roll over and accept incompetent, unethical malpractice, then that's what you'll get. Okay. I'm fighting. You see that. I'm doing it. And so now is the time. And get the media over here. Get the media focused on this situation. Let's get the court reforms that we needed, that are needed, not only for you and your family, but for all families everywhere. Once the United States starts to happen, California pulls forensic custody evaluations. They get pulled from everywhere. Now we need something. Those are clinical diagnostic assessments. We start returning that, getting the competence up. You see the whole diagnostic series as your consultation. People can learn what they're doing, and we can get effective clinical services into the family courts to begin to solve and fix the pathology in the family courts. The moment it hits the U.S., it'll move immediately up into Canada. It'll move out to the Great Britain and down to Australia, over into Scandinavia, and all of a sudden everything starts to ripple into the court reform that has been needed and is necessary to stop the child abuse that's currently going on in the family courts and spousal abuse. So with that, I'm going to and I say good day and head off to the rest of my day, the rest of my Sunday coffee. And we'll check in with you next week. So take care, everybody. Good luck.